Hey there, my friends! Welcome to those of you who are watching us for the first time, and to those who are already sharing this journey with the Academy. Thank you so much for joining me again. Here we explore international law. The two playlists mentioned above trace the paths we have taken so far, and today I am here to take that journey further by drawing the law alive. We have been talking about the subjects of international law, a topic you can revisit through the videos already created in my playlists above. And in today's video, we will talk about exceptional or contextual subjects of international law. Ready your curiosity, and let's begin this new chapter together. In international law, subjects do not all stand on the same ground. They are arranged in clear categories according to the breadth and purpose of their legal personality. First, we have the full subjects of international law, those endowed with a general international legal personality. And here, international law recognizes only states, a category we have already explored in our earlier videos on the subjects of international law. Next come the derived or secondary subjects, entities that exist and operate on the international plane because states have allowed them to exist. This category includes international organizations and supranational entities, which we have also examined before. Then we encounter limited or functional subjects, actors whose international legal personality exists only for specific purposes. These include individuals, non-governmental organizations, and transnational corporations, all of which we have already covered. And today we turn to the final category, exceptional or contextual subjects of international law, actors that become subjects only within particular legal contexts. So who are those? Well, the first category includes protected states, trust territories, mandated territories, and territories administered by the United Nations. These entities do not enjoy full and independent sovereignty, yet they are not legally invisible. Their international legal personality is limited and functional, shaped by international agreements, trusteeship arrangements, or UN administration. In such cases, international law recognizes a form of subjectivity because governance is exercised under international supervision, often to safeguard peace, self-determination, or transitional stability. Thus, even without complete sovereignty, these entities may still operate as subjects of international law within a defined legal framework. Then, we encounter governments in exile, which form another exceptional category. A government in exile arises when the lawful authorities of a state are forced to operate outside their territory due to occupation, coup d'etat, or unconstitutional seizure of power. Despite the loss of effective territorial control, international law may continue to recognize such governments as representing the state, provided they retain legitimacy and international recognition. Their legal personality is therefore representative rather than territorial, allowing them to maintain diplomatic relations, conclude agreements, and act on behalf of the state until constitutional order is restored. Then it's the Holy See, which occupies a truly singular position, one that does not fit neatly into the classical definition of the state, yet cannot be excluded from the international legal order. Alongside very small political entities such as San Marino, Liechtenstein, and Monaco, the Holy See represents a form of international presence that challenges the traditional criteria of territory, population, and government. But unlike those microstates, the Holy See's international personality is not grounded in territorial sovereignty, but in its spiritual authority and historical continuity. The distinction between the Holy See and Vatican City is fundamental. The Holy See refers to the central governing authority of the Roman Catholic Church, embodied in the Pope and the Roman Curia, while Vatican City is the territorial entity created to guarantee the Holy See's independence. This special status was formally recognized through the Lateran Treaties of 1929, concluded between the Holy See and Italy. Through these treaties, Italy acknowledged the Holy See as a subject of international law and established Vatican City as a sovereign entity, granting it a unique legal and political position. Despite this sovereignty, Vatican City functions as a state with a special statute, often described as a quasi-state. Many essential services, such as public order, criminal enforcement, and certain judicial functions, are exercised by Italy, based on treaty arrangements. Even so, the Vatican maintains its own legal system, administrative structure, and internal governance, all ultimately centered on the authority of the Pope. Nationality within Vatican City is also exceptional. Vatican nationality is not permanent, but functional. It is granted only to individuals who reside or work in service of the Holy See, and it ceases once that service ends. What truly distinguishes the Holy See is its international legal personality, which exists independently of Vatican territory. The Holy See maintains diplomatic relations with a large number of states, sends and receives diplomatic representatives, and concludes bilateral treaties known as concordats. These concordats regulate relations between the Holy See and individual states, particularly on matters such as religious freedom, education, marriage, and church property. Through these agreements, the Holy See acts as a full participant in international legal relations. The Pope, as the head of the Holy See, exercises the right to appoint diplomatic representatives, nuncios, and administrative envoys, reinforcing the Holy See's role as an active international actor. This practice confirms that its personality is original, stable, and universally recognized, even though it does not resemble statehood in the classical sense. In international law, therefore, the Holy See stands as an exceptional but undeniable subject, not because it controls territory like a traditional state, but because international law has long recognized that authority, continuity, and independence can exist beyond geography. It is a reminder that international legal personality is not a rigid formula, but a reflection of historical reality and legal necessity. After that, we should mention, people, one of the most profound issues connected to the legal status of individuals is the right of peoples to self-determination. This right did not begin its life as law. It was first a political aspiration, a voice rising against domination. Over time, it crystallized into a legal principle, and today it stands as a peremptory norm, just cogens, of international law. Wherever peoples are subjected to colonial domination, foreign occupation, or racist regimes, international law recognizes their right to determine their own destiny. Long before this legal maturation, related ideas had already taken shape, such as civil disobedience, famously articulated by Henry David Thoreau in protest against unjust taxation and war. Civil disobedience was collective, principled, and nonviolent, revealing an early moral resistance to illegitimate authority that later informed the legal evolution of self-determination. The right to self-determination has two dimensions. Internally, it means the right of peoples to participate freely in governance through genuine elections, political participation, and representative institutions. Externally, it refers to the right of a people to establish an independent state or political status of their own choosing. And international jurisprudence has cautiously acknowledged this external dimension. In its advisory opinion on Kosovo's unilateral declaration of independence, the International Court of Justice did not find such a declaration contrary to international law, implicitly recognizing that external self-determination may operate as a remedial right where a population is subject to systematic and grave human rights violations. In these exceptional circumstances, peoples themselves emerge, briefly but powerfully, as subjects of international law, not merely protected objects, but legal actors whose collective will carries juridical weight on the international stage. Next is national liberation movements. After the Second World War, the map of the world began to breathe differently. Across Africa, Asia, and parts of the Middle East, peoples who had lived under colonial domination rose with a collective voice, forming what international law came to know as national liberation movements. These movements were not random uprisings. They were organized expressions of a people's right to self-determination, a right that emerged powerfully in the post-1945 international legal order. One of the most emblematic examples is the Front de Libération Nationale, FLN in Algeria, which transformed an anti-colonial struggle into an internationally recognized movement, forcing international law to confront a new kind of actor, neither a state nor a mere insurgent group, but something in between. International humanitarian law played a decisive role in this transformation. The four Geneva Conventions of 1949 and more explicitly, Additional Protocol 1 of 1977, opened a legal door for national liberation movements to enter the international legal sphere. Article 1(4) of Protocol 1 recognizes armed conflicts in which peoples fight against colonial domination, alien occupation, or racist regimes as international armed conflicts, provided certain conditions are met. These movements must have an organized command structure, exercise control over territory, conduct military operations in accordance with humanitarian law, and respect the fundamental rules protecting civilians and prisoners of war. Once these conditions are fulfilled, national liberation movements are no longer treated as internal rebels. They acquire a limited international legal personality, particularly within the framework of international humanitarian law. This recognition was not merely theoretical. Some states went further, granting formal recognition to national liberation movements and even establishing diplomatic or quasi-diplomatic relations with them. A striking example is SWAPO, Southwest Africa People's Organization, which was recognized by the United Nations as the legitimate representative of the Namibian people during their struggle against South African apartheid rule. SWAPO was allowed to participate in international forums, receive international assistance, and represent its people on the global stage, long before Namibia became an independent state. Through such recognition, international law acknowledged that legitimacy can arise not only from sovereignty, but also from representation of a people and adherence to humanitarian norms. Ultimately, national liberation movements became subjects of international law not because they replaced states, but because international law evolved to respond to historical necessity. Their international personality is contextual and functional, limited primarily to humanitarian law and self-determination, yet powerful in its implications. They demonstrated that international law is not frozen in treaties alone. It moves with peoples, struggles, and moral demands of its time, recognizing authority not only where power exists, but where justice seeks a voice. Then we should focus on belligerent armed groups. They are not subjects in the classical sense, and yet at certain moments, international law is forced to see them, name them, and regulate them. These groups emerge within internal armed conflicts, when an organized non-state armed group confronts the government of a state with such intensity and structure that the conflict crosses the threshold of mere internal disturbance. At that point, international law does not recognize their cause, but it recognizes their existence, because silence would mean legal chaos. Historically, the concept of belligerency developed in the 19th century, long before the United Nations system, as a pragmatic legal tool. When an armed group demonstrated effective control over territory, a responsible command structure, sustained military operations, and the capacity to respect the laws of war, third states could recognize it as a belligerent party. This recognition did not grant sovereignty, nor political legitimacy, but it produced limited legal effects. The application of the laws of war, the possibility of neutrality obligations for third states, and the acknowledgement that the conflict had an international legal dimension. In contemporary international law, belligerent armed groups find their legal relevance primarily through international humanitarian law, especially Common Article 3 of the Geneva Conventions and Additional Protocol 2 of 1977. These instruments impose obligations directly on non-state armed groups, regardless of recognition. Once a group is sufficiently organized and the violence reaches the level of a non-international armed conflict, humanitarian law applies automatically. In this sense, belligerent groups become addressees of international legal norms, bound by duties to protect civilians, prohibit torture, and respect fundamental humanitarian standards. This is where their limited subjectivity emerges. Belligerent armed groups do not possess general international legal personality, but they are treated as functional subjects within a specific legal regime. They can commit international crimes, incur individual criminal responsibility, enter into special agreements with states or international organizations, and be held accountable before international tribunals. Their legal visibility exists not to empower them politically, but to humanize armed conflict and prevent the collapse of legal protection for victims. So, are belligerent armed groups subjects of international law? The answer is yes, but only conditionally, contextually, and reluctantly. International law does not recognize them because it approves of them. It recognizes them because war creates facts that law cannot ignore. Their mention is essential, not because they expand the list of subjects, but because they reveal a deeper truth. International law sometimes speaks not to authority, but to violence, attempting, even in chaos, to impose limits, responsibility, and restraint. Finally, international courts and tribunals. In the quiet architecture of international law, courts and tribunals emerge as guardians of order, their authority flowing from the consent of states and the framework of treaties. They are exceptional subjects, not in the way states exist, but because they wield powers that affect states, individuals, and organizations. The International Court of Justice, for instance, derives its existence from the UN Charter, resolving disputes between states with binding judgments, while the International Criminal Court holds individuals accountable for the gravest crimes, acting where national jurisdictions cannot or will not. Their subjectivity is functional, limited to the legal authority conferred upon them. They do not make laws, yet they interpret and enforce them, shaping the practice of international law. In this way, these tribunals are living instruments, bridging consent, obligation, and justice across borders. A reminder that even in the abstract realm of states and sovereignty, law has a voice that can command, arbitrate, and protect. And now, my dear friends, I turn to you, the curious travelers of this journey. Are there any more subjects we haven't discovered yet? Can we imagine others? Perhaps new actors rising on the horizon of international law? Could AI one day step onto this stage? Could tomorrow's innovations become tomorrow's subjects? Let your minds wander. Let your questions dance. Today, we have reached the final destination of our playlist on subjects of international law. Together, we have drawn a canvas rich with colors and shapes. Each stroke has revealed a story, each line a principle, and each shade a nuance of law coming alive. Thank you truly for listening, watching, and walking this path alongside me. May you carry this journey forward, always alive with curiosity, creativity, and imagination. Keep your colors bright, your shapes bold, and let the law, like life, be drawn with passion and care. Okay? Until we meet again, remember, my friends, the world is a canvas, and you are the artist. Draw life alive. This is Dina, signing off with best regards.